Good morning, everyone. This is the BET workshop on Railroad Plaza. I'd like to call the meeting to order at 9:05. Will everyone please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As one of my colleagues said, this is an unconventional BET workshop, which is typically a more informal discussion. But since we have so many people in attendance today, we're set up a little differently, maybe a little bit awkward for conversation, so I apologize for that, but at least we'll get the job done. As many people know, there was a presentation made on the Railroad Plaza development. It is on the I understand it's intended to be on the RTM agenda. We have many RTM members in the room. I did make the decision that we would, after the BET conversation, open it up to questions from interested people in the room, since we have the opportunity to have many of the town officials and the representatives from the developer in the room with us, and that would allow us to have a more constructive conversation. I'll ask that we start with the BET discussion and BET questions, and once we conclude that, we'll open it up for public discussion. I'd like to thank representatives from the town and also from Greenwich Plaza for being here. I would like to start with just maybe we could take a few minutes to do introductions. Mr. Tessie, perhaps you can start with who's here from the town.
Good morning, Madam Chairman and members of the BET. Guests, members of the RTM. My name is Peter Tessie. I serve as your first selectman, I think for another 70 days.
He's counted.
To my left is Daryl Harvey, who is the co-CEO of Ashforth Properties, and Ben Branyan, our town administrator. Bruce Cohen, attorney for Ashforth, and Ryan Harvey from Ashforth. Did I leave anyone out?
And Adair Greenfeld, our general counsel from Ashforth, and James Moran, who's executive managing director at Cushman and Wakefield, our appraiser.
Yes. David Morrison, who's our outside counsel, he just stepped outside. Steve Olvaney, who's the appraiser, is en route. He was just taking a quick call with them on, I think he's stuck on 95 somewhere.
Yeah, it's slow.
Yes, and thank you all for being here and for doing so much work in advance to address some of the BET questions that you received in advance. I do want to start with a thank you to Greenwich Plaza for their tenancy in town and their work on behalf, and I thought maybe, Mr. Harvey, if you could give a very brief introduction and also to set the framework for the discussion. Tell us about the conversations that you've had, how this development proposal came up, and maybe a little bit about your conversations with the town to date. Ms. Tarkington?
Yes, Madam Chair. Could you just explain to us why this is a workshop and not a special meeting of the BET, or this kind of discussion being done in a regular meeting? And also, I would ask that a court recording be made of this particular meeting, because we have open planning and zoning meetings, and as has been introduced, we have land use attorneys here. Some of the discussion may be pertinent to these open applications, so I would ask that a court recording be provided to planning and zoning, and that you, as chairman, ask Mr. Luca that it be included in the public record for the planning and zoning, all of the open applications for planning and zoning.
Thank you for your inquiry, Ms. Tarkington. On your first question as to why this is a workshop, there was a request by BET members for a workshop so that they could have their questions answered before it comes before us officially as an agenda item for deliberation and discussion. This allows us to be informed in our decision-making, and as we meet in public, it is a public workshop, and since it is on the agenda for the RTM as well, There's a considerable amount of talent in the room that have the ability to answer questions. In the interest of transparency and open government and communication amongst boards, we decided to open, and I decided to make the decision that it benefits all residents to have the RTM members and others in attendance, if they have questions that they want answered, to be able to answer it. So it is not we're going to move on with the agenda. We have a time constraint here. We're going to, we have the room until 12, but I'm not intending to keep this meeting going past 11:30. So I'd like to continue with Mr. Harvey. If you could please tell us a little bit about what brought up, I'm not,
Couldn't the same-
no, Ms. Tarkington, we're moving on with the discussion. Mr. Harvey, can you please tell us a little bit about your discussion, how we got here?
Sure, and I thank you for having this workshop to better understand this both aspects of this of what we in the Selectman's Office are proposing to the town. I will say it's quite a bit of a long history here. Wasn't quite sure what as the chairwoman has said, I wasn't quite sure what the format was going to be, so I don't have a nice, crisp synopsis of the history. I didn't realize, frankly, that I was going to be doing this, but I'm happy to do it, and I'm ad-libbing, so let me try to run through the history as quickly as possible. And most of this, or virtually all of it, is on the town website. Many of you probably are already aware of it, but this is the product of probably 5 or 6 years of discussions with the town, centering on two issues. I call them sort of our two sort of 50-year issues that we're dealing with as owners of Greenwich Plaza, and they're both intertwined. The easier one to understand is as owners of the entire complex there, including the properties on Railroad Avenue, we are faced with some physical issues that we have to deal with on the Railroad Avenue property, which we've known have been upon us for a number of years, and that's why we've been talking with the town and particularly with the P&Z about what we should do about these physical issues. Let's call that the sort of the redevelopment, physical redevelopment aspect of the property, and that's mainly in two forms. One, the theaters are, that building is basically defunct or inefficient. Neither we nor the movie company Bowtie wants to put any money into it. We're keeping it alive. They're not making much money. We've agreed with them. They're not paying us much rent while we try to figure out what to do with it. But it's not going to be rebuilt. It's not appropriate for current movies or where the cinema industry is going. And so we have to do something radical to that, and to maintain movies, which we received clear indication that the town would like to retain its movie theaters. We've worked very hard through a number of different plans on a way to make the movie theaters work in Greenwich. That resulted in a need, because of the size that you need for the building, to do multiplex theaters to be competitive, to move it to the other side of the block, to Railroad Avenue, on Railroad Avenue. In order to do that, we have to elevate it up in the air, but we've incorporated that into our design. So that was the first problem. Second is that we believe that the railroad station should be upgraded. We built it 50 years ago, and it needs to be redone. There's several different ways of handling that, either just restoring it and giving it an uplift and maintaining it, which is our obligation, which we'll continue to do as we have been. But there's also, we thought, an opportunity to do something really exciting with the train station, try and do something more reflective of where things are today and where they'll be for the next 50 years. So we spent a lot of time on that whole issue, particularly with the P&Z and talking with the First Selectman's Office about what would be the best way to address that problem. It's a long-term investment for us. The benefit of it would be For us, even though it's really just rearranging everything we have there now, doesn't add much retail, a couple thousand feet of retail, otherwise it provides a new train station. It also retains the theaters at quite an expense in terms of building these up in the air. And when we worked with the town, it became clear that creating a nice open space where the theater is rather than the big block building made sense, because Greenwich has changed and the downtown has changed dramatically. But to make that kind of an investment and do what we think is the right project there, and what I think the First Selectman's office believes is the right project, that's a long-term investment for us. And the benefit that comes from that is that we own both sides of the tracks. We own the buildings on the other side, and over the long run, I think it will boost the whole area, and everyone would benefit, the town with its grand list and so forth, and we as owners in that area, just as the building across the street would benefit dramatically from what we'd be doing. We think restaurants benefit with the theater complex. There are a whole bunch of things that we think lift us. So if we take a long-term view, which we do as a family company, that this would be very good for us and for the town. But for us to get to problem two, the second 50-year problem, is for us to really be confident of that long-term benefit to both sides. We need to resolve our issues with the air rights lease on the south side, because that, even though there's 38 years left to go, that's starting to impact our ability and our incentive to invest on that in that property. And it's going to get worse as we have bigger decisions to make, such as if we redo the entire curtain wall on the building, that's a 50-year investment. What's the ownership situation and the air rights? This is the more complicated part of the transaction, and that's really why we're here today, and where the BET is involved, because we're saying that we will provide a certain amount of public benefits on the north side of the tracks in return for resolving the long-term ownership situation of the air rights on the south side, which we already rent, which we have built out completely. There is no new building that would occur on the south side whatsoever, except the south station, which we've also proposed, which I neglected in my first description. In working with Metro North and ConnDOT, we have determined that it makes absolute sense to build a south side station, as we're calling it, because of the commuting and travel patterns now projected by Metro North and ConnDOT. Plus, we would invest in a much improved drop-off and pickup on both sides of the tracks, on the north side and the south side, which requires us to, at quite an expense, move our block structure that separates our visitor parking lot on the south side. So the concept, after a lot of discussions with the town, explaining that we couldn't make a long-term investment in this complex unless we knew that the long-term ownership was resolved, and the air rights that we had leased would convert to our ownership. The lease does provide we're able to make an offer based on an appraised value, but it's in the town's discretion as to whether they would sell to us or not. So being able to accomplish that now would therefore justify us making this major investment in the north side, plus additional investments in the property, like looking over the next 5-10 years probably at a whole new curtain wall potentially for the buildings, both the portion that's on our property and what would at the end of the air rights lease end up on the as town property. So in order to accomplish that, we spent a lot of time working with the First Selectman's office. All the selectmen were aware of this going back over a year, in terms of the fact that we were working on this. The town hired their own attorneys. They hired their own appraisers to figure out the value of what we'd be providing on the north side, as well as actually the appraisal of the value of the air rights. And then that, I think, to try to wrap it up, the biggest question that has driven is how you value air rights. And for those of us in real estate, particularly people who've dealt in New York, dealing with air rights is relatively common. For people who haven't, it's a difficult concept to understand. And as our appraiser, Jim Moran from Cushman Wakefield has said, who's been doing this for, I don't want to guess how many years, maybe 30, 40 years, whatever. And you have 40 years, and Steve Olvaney, the town's appraiser. None of us have ever seen a situation like this on either a ground lease or an air rights lease where a property gets divided in half at the end. So even for real estate people, this is a complicated aspect. And then trying to value that in the future and present value it to today. All real estate people now, all investors, all lenders use discounted cash flow analyses when they're making a real estate investment, which is basically the concept of present valuing what they think is going to happen in the future. If you're not used to doing present values, it's quite surprising the difference between a value 40 years from now and a value today. So that has probably become one of the biggest issues that relates to the BET, which is completely understandable. Why is this a fair value, what's being proposed? And I apologize for trying to cover an awful lot of history here in just a few minutes, but if anyone on my group, or Ben, have I left out anything? Because this has all been done in coordination with the town, resulting in our proposed redevelopment agreement that covers both these issues on the north side and the air rights issue on the south side. The other thing that thanks, Ryan, is that the other uncertainty that we're trying to resolve is that part of the deal that was made in 1967 with the air rights lease was that the portion of the ground level that now is A level, which is the commuter parking lot, we would allow half that land, our ownership of that land. We would give a long-term license to the town to use it for parking on the commuter side, along with the half of A level that is owned by the town. I don't want to go too much into the details of the deal when this was all set up, but the end result is that license expires at the end of the lease. So in not only does the town get a portion of the office buildings if the lease goes to its conclusion, but we get back full use of our portion of the commuter lot. So the town would no longer own half of what the commuter lot is. So the town is anxious to have that uncertainty be resolved also. So the ownership of the air rights, which we already lease, and the continuing use of A level for the town when the license ends is something that the town would like to have resolved as well. All those things, plus a few more that I'm sure I've forgotten, are covered in the redevelopment agreement, which is on the town webpage, and that is the financial aspects of that and the valuation of the air rights and the methodology we've set up for valuing the public benefits we'd be providing in comparison to the value of the air rights is, I think, probably the central issue that brings it to the BET. For us, forgive us, we are working through the Board of Selectmen, the P&Z, the BET, hopefully through the RTM, and with a few stops at the Architectural Review Committee too. So it's a little tough trying to keep track of all the different groups that we're wending our way through under the capable guidance of Attorney Cohen, who has a lot more experience in this than I do. I hope that's enough of a background.
Yeah, thank you, Mr. Harvey. What I was hoping to do was just give everyone an overview of how we ended up here. We hear that question a lot. Just to highlight, I think you indicated that you've been talking to, and as you mentioned, there are lots of different parties in the town, so I would just ask if you can clarify as we go through which parties. It sounds like you were predominantly speaking with the First Selectman's Office, and possibly P&Z at times, as opposed to members of the other boards and commissions, including the BET and RTM. But you started this conversation with the First Selectman's Office 5 or 6 years ago, and that it picked up over a year ago in full steam to reach the agreement that we have before us for consideration
Yeah,
today.
and a little over a year ago, we spoke with all three selectmen and explained the deal that we were proposing, and I will say, which is surprising in this kind of a situation, what we proposed back then and explained to all three selectmen is almost exactly what we have proposed still
Right. Right.
as the current deal. So that's been entirely consistent for the last year.
And
And then we've put together our P and Z proposals, and we're partway through P and Z now. And we've had an RTM session. We have not gone to the IARC yet, but we've had several sessions with your committees.
Right, right, as well.
And B2, and individual discussions with members of boards to answer questions and so
Right.
forth.
So, and when you refer to something like the town wanted to retain the movie theaters, you meant the first selectman's office or P&Z. I'm not sure when you say the town want, elements of your
I
design,
understand. Yeah.
if you could clarify.
The feedback that we got primarily on the theaters was from P and Z at the time.
Okay.
That they said they would really like it if we would find a way to retain the theaters.
And the Pocket Park?
And the Pocket Park came up through the discussions with P and Z also.
Okay. Thank you for clarifying that.
Ms. Oakley?
Ms. Tarkington?
When you say P and Z, you don't mean through their commissioners, you mean through their administrative office,
Yes.
is that correct?
Through-
I just
through-
want to clarify that.
Yes, through the meetings with the staff
Right.
and trying to also going through with the first selectman's office the plan of conservation and development and what the goals were there. So it was a joint discussion with the
With staff.
with the first selectman's office and with staff from P and Z, which is I think a normal process for.
Sure.
Right,
We
but
do
so-
that a lot with P
Thank-
and Z before spending a lot of time on plans and so forth, try to get a feel from the staff as to what they would like to see.
Right, thank you. So thank you for setting the table for our discussion. I do know that members do have questions about the financial terms of the deal, as well as the structure of it. So I'd like to open it up initially to BET members to see if there's anything that they would like to focus on. Any? Sure, Mr. Tessie.
So as we've heard, I mean, this has been over a 50-year relationship with the town of Greenwich, and during that time, at least within the period that I've been here, Greenwich Plaza has made several appeals of their valuations. Looking back through my records as I move through things through my office, I see that in 2008, we had a property tax appeal settlement handled through the assessor and then the town legal department. I see Mr. McLaughlin here. Those matters go before the board and are voted, the Board of Selectmen voted on in public. But the one consistency that came through in the memorandum that we received was the termination of the air rights lease. And that particular concern was enumerated back in 2014 by Attorney McLaughlin, referencing the judge at the time who oversaw this, Ken Provator, that we do something to address the uncertainty that the eventual termination of those rights would have. So I just want to incorporate that into the discussion because assessment is an area that is the purview of the BET, and your professional person has been an integral part of responding to these appeals along with the Board of Assessment Appeals, another elected body, as well as the town attorney's office through Assistant Town Attorney Gene McLaughlin, who's here. I think the years were 2008, 2014, and 2015 that there were various settlements on appeals brought forward.
Thank you, Mr. Tessie. Yes, and our assessor, Lauren Elliott, is here, and I'm sure there are going to be some questions about the assessment process as well that, in her expertise, she'll be able to address. Mr. Weisbrod.
Thank you, Madam Chair. Maybe we can start. I have a series of questions to ask several of the people that are here today. Maybe we can start with the assessor, if she's here, Ms. Elliott. Maybe if If you don't mind going to the mic so that we can all hear you, that would be great. Welcome. Hello.
Good morning.
Nice to see you. So to help us understand this, can you explain how what is computer-assisted mass appraisal, and how that works when you determine assessed values?
When I'm determining assessed values, I do it basically en masse as a whole. I am not making an individual appraisal of each property. To do that in the town of Greenwich, there's 22,000 parcels. That would be absolutely impossible for us to it's something to do. So what we do when we come up with this assessment is we create basically models that we then apply throughout the entire town depending upon the type of property. So since we're talking about an office, we'll use that. So basically I have a price per square foot for all offices. I have a vacancy, I have expenses, and I do an income approach. And I also do, we have a CAMA system, which is a mass appraisal system. And basically, I apply those same figures and facts to all other similar properties and similar assessments. So when we come up with a value for fair market value, it's done en masse, which is different than doing an actual specific appraisal, fee simple appraisal that may be done on this.
And so you create an algorithm and you
Yep.
put it into some kind of a computer model, which is why you call it a mass appraisal, right?
Correct.
And how often do you do the algorithm?
We do it once every 5 years.
Every 5 years. And you use this comma methodology when you assessed Greenwich Plaza?
Yes, I did.
Okay. Did you actually, when you assessed the value of Greenwich Plaza, you did not therefore use the actual rent roll, although you may have access to it when determining the value, you didn't deploy the specific, property-specific data about Greenwich Plaza? Is that
No,
right?
no,
Okay.
and nor would we do that for any property. We basically try to get, we try to get what we call market rents. So if somebody has entered into a lease in Greenwich Plaza 20 years ago, that's not reflective of a current market rent. So we look at their actual expenses and their actual income like we do all the other office buildings. However, we do not take their actual rents. We come up with what we consider a market rent for that building.
Right. And does the comma model have a vacancy rate?
Yes.
What is the vacancy rate?
It's depending on where we are in the town of Greenwich for office. It ran from 3 to 7 to 10 or 15%.
And what would you, for office space here, would it be?
Downtown, we were at 3 to 5% at their last 2015.
Right. And do you know the actual vacancy in this property?
As of 2015, I have their income and expense, but I don't know it off the top of my head, nor can I disclose that. Their income and expense information is confidential.
Oh, it is confidential?
Yes, it is.
All right. And so the specific date, have you shared the specific income and expense data with the Selectman's office?
No, I don't believe I have. I'm not allowed to.
You're not allowed to, correct?
Yeah.
In your view as an assessor, is it common to use assessed values as an independent study for determining market value for the purpose of purchase and sale of property? Is this something that's common, is that what the assessed value is about?
Well, we're supposed to come up with fair market value, but it all depends. I mean, we have litigation that says, all my assessments are far too high, but then, properties turn around and they sell for far greater than what I actually have assessed them for. So, it depends on the property. It depends on, like I said, we don't get down to the nitty-gritty and the specific of each individual property. This is a mass appraisal. I don't get into the weeds as much as somebody who is doing a fee appraisal would.
Thank you. One last question.
Mm-hmm.
The next mass appraisal will occur next year, right?
2020,
Do you
correct.
expect the value of this property or values in the office space to go up? What's your sense?
I think they will probably, I know they'll go up because our vacancy has gone down. We have actually, over the course of the last 5 years, seen vacancy. We had a lot of office vacancy. We're seeing less of that now. It's starting to be absorbed. But I'm going to keep, I don't want to put myself in a spot
No, I
here.
understand.
Can I clarify? Could I
Thank you.
just
Thank you, Ms.
Yeah,
Elliott.
okay.
Mr. Harvey?
Yeah, I'd just like to clarify one thing, and I'm not in any way disagreeing with what the assessor has said, but I think she'd probably agree with me that when we appeal, and this is going to be litigated or a settlement's going to be reached on what the proper assessment is, then a discussion of what fair market value of the building is becomes the topic of the actual litigation. And so when First Selectman was referring to Judge Providore and so forth, we were deep into what the actual fair market value was, what the rents are, what the value of the air rights lease, the infringement of the air rights lease, or the impairment of the air rights lease, and so forth. So once you do get into litigation or you have an appeal of this, then that property is singled out, and then we have a full discussion with the judge and so forth as to what the fair market value fair market value is from which the assessor determines her assessment. So whenever we do that, it either goes to trial, goes to the judge, or a settlement is reached based on the involvement of the judge and a full analysis of what the fair market value is. So in terms of using that for evaluation related to a purchase and sale, it's a fair market value that was reached after a judge having been involved and full discussion of what the actual rent, expenses, and so forth, vacancy, capitalization, all the discounted cash flows, as I was talking about earlier, all become part of that discussion. I just wanted to make it clear that and an awful lot of properties end up in some sort of discussion on this issue of is it a fair market value. And I will say that in each case we've done that with the assessor, we've reached an agreement that we thought was reasonable for both sides.
I wonder if Mr. Ulvaney has come yet? Yes. Mr. Ulvaney, thank you. Welcome to our BET. So in your July 1st, 2019 report, Mr. Ulvaney, you note that the work constitutes, quote, a restricted appraisal report. Can you explain the difference between a restricted appraisal report and a normal appraisal report?
In the appraisal world, and I've been an appraiser for, as somebody said, I started the business in 1987, so the rules have changed over time. But to directly answer your question, a restricted appraisal is basically done restricted to a specific client, not to be used by other clients, and people that read the restricted report are supposed to have knowledge of the property or knowledge of the appraisal process. We have another report that's called a comprehensive report, and these standards are set by the Appraisal Institute. A comprehensive appraisal report, for lack of better wording, is more pages. You'll have 15 pages on where Greenwich, Connecticut is and where the state of Connecticut is. At the end of the day, the value from a restricted report that comes out on the front page of the report should be exactly the same value as a comprehensive appraisal report.
Do you abide by the uniform standards of professional appraisal practice?
We sure do.
Okay. And in the uniform standard of appraisal practice, what is their distinction between a restricted appraisal report and a normal actual appraisal?
Just what I explained.
Right. And does it say that, will a bank take a restricted appraisal report?
A federally regulated bank by the United States Congress cannot. It's against
Say that again,
banking law.
what?
A federally regulated bank from the Congress is not allowed to.
A bank is not allowed to take one.
Correct.
Will the IRS take a restricted appraisal report?
We've submitted reports to attorneys that are used for the IRS that go for tax purposes. I've never had a kickback. A lot of times we will recommend to the attorney that's going to the IRS for whatever reason to use a comprehensive appraisal document. It's up to them. I've never been called in by the IRS, but I've been called in by assessors.
And why won't a bank accept a restricted appraisal report?
It's federal banking law.
No, it's maybe federal banking law, but isn't also included in the uniform standards of professional appraisers that the report is deemed to be for the client who has extensive knowledge about the property itself. Is that right?
Say that question
That
again?
the reason for a restricted appraisal report is a report given to the client itself for the client's own internal purpose on the basis that the client has a detailed understanding of every aspect of the property. That's why a restricted appraisal report exists.
Yes.
And how, in your practice, are most of your reports restricted, or most of them are normal reports?
Most of them are not restricted.
Most of them are not restricted.
There's no
Okay.
such thing as a normal report.
Your July 1st letter says also that the conclusions, this is a quote, conclusions may not be properly understood without additional information contained in the appraiser's work file. This is a red flag. It's intended to be a red flag. What is in the work file, and would you share that work file with us? We would like to know.
The work file, the biggest thing in the work file is going to be the lease. I read the lease documents and all the other documents relative to that. The copy of the lease is not inside my appraisal report. There's a lease summary of it. You'd have to read the entire lease, which dates back to 1967. I don't know if everyone on the BET has read it, but I have, so we don't put it in there. That's what.
So you state
Correct.
that as an extraordinary assumption that the market value is assumed to be equal to the 2015 assessed value. Is that correct?
Correct.
We just heard from the town assessor who said that they really don't do the assessment based on a specific rent rolls, property-specific, detailed, unique property kind of, as they do aggregate mass appraisals. Is your appraisal, your restricted appraisal, generated from a mass appraisal emanating from the assessor's report, or did you actually use the existing rent roll, existing expenses, existing vacancy rates specific to that property?
We use the assessment from the.
Is it normal to use the assessed value as opposed to an appraiser going in and actually looking at the actual rent, the actual expenses, and the actual vacancy rate?
Yes, I've done it before in my 30-year career.
You're saying that that's normal?
I've done it before in
You've
my
done it
career.
before, but is it a normal, it's understandable why a bank wouldn't accept that. They want to know what's the rent roll, right?
In every single appraisal that I've done, we always look at the assessment versus the market value that we derive.
Versus, but here you're using the assessment as the premise for the market value, not versus, right?
In this document, what you're talking about with the value at the end of the day is $9.9 million. That's one factor in the.
No. You say in your report that the market value is based, it's derived, you just told us a second ago that you did not look at the specific rents, the specific expense, the specific vacancy rate. Instead, you took what you got, assessor who uses a computer mass-generated model. This is not comparing one with another. This is the value that, under your restricted appraisal report that you produced. Isn't that right?
That's correct.
Thank you. Did your appraisal take into account the higher rent or other benefits that Greenwich Plaza would derive as a result of the refurbishment of the retail part of the property?
No.
No, it did not. Thank you. Now, you deploy a 10% discount rate in your analysis based on some comparables. Do you think that that a 10% discount rate is an appropriate discount rate in a world, we're talking about a prime piece of property with prime tenants, and in your own words, in a, quote, very good location at the Greenwich train station, at the Interstate 95 exit, and at the base of Greenwich Avenue. A 10% discount rate for cash flows when the 10-year U.S. Treasury rate is 1.5%.
Yes, I do.
Thank you. No other questions for you.
Mr.
have
Weisbrod,
questions.
before you move on, do any other BET members have questions specifically for Ms. Elliott or Mr. Olveni on the appraisal process or the specific appraisal that was given to the town?
Could I make one more?
Yes, Mr. Harvey.
Just addressing a comment that Mr. Weisbrod made in the use of the fair market value in effect determined by the assessor's office, from which it takes 70% of that number to arrive at the assessed value. Just reiterate, in this particular case, that final fair market value, that final assessment which was agreed to, was a result of the court proceeding at which all the items that Mr. Weisbrod has been referring to were very carefully reviewed, including market rents at the time, expenses, and so forth, under a judge's purview before the final assessment was reached. So it was very scrutinized, and that was the settlement that was reached. Judge Provodator was not the judge who decided that. He had instructed us earlier when we went to him trying to work through a different process that we should try to resolve this issue, because it was going to continue to be an issue going forward between the town and Greenwich Plaza, and that we should that his advice was that it should be addressed. But I just wanted to make it clear that the number that both appraisers, our appraiser Jim Moran at Cushman and Wakefield, and Steve Olveni, both used in the town, and we thought was a reasonable place to begin, was because it was a fair market value that was arrived at through judicial proceedings with full information. And I would further add that when you get into this present value analysis, there were slight differences in the number we used at the beginning, but at the end of the day, when you get into present value, trying to distinguish a 5 or even 10% difference on the starting value when you're valuing something about 40 years from now, frankly, does not have a major impact on the analysis, which I think you would agree with, but is part of the process. But that's just a little more background on why, rather than commissioning and paying for a whole nother appraisal of what the property is worth today, that this was a reasonable stand-in for the value, and we would still say that's was a very reasonable appraisal, and the town and we agreed that's what taxes should be paid on, and that's what we've been paying taxes on for the last since 2015.
Ms. Tarkington.
First, I would like to add just here that we all appreciate Greenwich Plaza and everything that, the Ashworth family has done for the town. And this is an important facility for all of us, and we want to work together to, come up with something that works for the town. But to work for the town, it also has to work for all of our town boards and commissions, and particularly for the residents of the town of Greenwich. This was originally written as a capital lease, and we have to remember that everyone was writing capital leases at that point in time to the best of their ability, and that there is a market value at the termination of this lease, and the town has some percentage, 53% or whatever, of that termination value. I think Mr. Weisbrod has asked some excellent questions, and I thank him for doing that. But what we're talking about is really sort of historic values and a process for assessment. What we all want, and I think is what you were talking about, if in a normal market you were to price this, or value it, or send it out to the marketplace, you'd be hiring an investment bank or valuing it. You'd be looking at the cash flows, the market conditions, and so forth. We haven't yet seen that process evolve, and it is our responsibility to make sure that as we move forward on this, that we're looking at this at the actual valuation process. I can tell you from my experience, the federal regulatory process actually does use and require and look at MAI appraisals. But for valuation, for sales values, generally, at least in my familiarity, there's a whole separate, valuation process to make sure that the other issues that haven't been addressed here are addressed. So I think we have a good base to go forward, but I think we can't forget that this is a capital lease. And in the BET Budget Committee, one of the things that I requested was, and in fact, I don't believe I received responses or answers to any of the things that I requested, but we'll just talk about this one, is your auditor's booking of this capital lease on your balance sheet, and whether it's on GPI's balance sheet or how it's reflected Ashforth or GPI. So again, I do thank David for beginning this discussion for us, and I think it's very helpful.
Okay.
And I thank you.
I also just had a quick question for Mr. Albany. An appraisal like this, what does it cost to perform?
Our fee for we did 2 appraisals, was $18,000, if I'm not mistaken.
When you say you did two appraisals, can you clarify that?
In our engagement letter with the town's attorney, we did one for the land valuation, and then another one for the air rights valuation.
Okay, and are those priced separately? So if someone, or was it $18,000 for the,
It was under one engagement letter?
correct? But were the pieces priced separately?
I don't recall.
Okay. So roughly, $15,000 to $20,000 to do this kind of appraisal?
Yeah.
Thank you. Yes.
Just to clarify, the 2 appraisals that were done, one was for the purpose we're discussing, the other was for the rent reset pursuant to the lease, which has its own valuation formula pursuant to the lease terms. The total fee for both was, as Steve said, $15,000.
So can you give me an estimate of what it would cost to do an appraisal for the sale of the air rights interest, since this was a combined engagement? Just wondering the order of magnitude to do the appraisal that we would be interested in.
Well, I would say it would be half.
Half. Thank you. Mr. McLaughlin.
On a microphone?
Yeah, Gene McLaughlin, Assistant Town Attorney. What Mr. Harvey has been referring to, I believe I have to correct, and that is that the appeal that was actually in court that I was involved in was from the 2010 revaluation, not the 2015. So the discussion that we had with Judge Provocateur was regarding a 2010 revaluation value, not the 2015 valuation. Just conferred briefly with the assessor. I think that what was determined as, and she can speak for herself, what was determined for 2015 may have been the result of some discussions between the assessor and the owner. It did not result, to my recollection, in an appeal. I can check those records down in my office if necessary, but just want to make that correction. Thank you.
Yeah, and
Thank you, Mr. McLaughlin. Ms. Elliott, did you want to add anything to that?
No, the only thing I would add is that we settled this appeal in the summer of 2015. So at that point in time, we were in the midst of our revaluation for 2015. We settled the appeal from the 2000, which arose out of the 2010 grand list. And since we were so close, we determined a value at that time for 2015 as well.
yeah. So in effect, the agreeing with the assessor, it takes a long time to settle these just because the 2010 assessment, it took us 5 years to resolve it. Of course, resolving it ended up in, since we were already at the next revaluation in 2015, in agreeing to the 2015 at the same time that 2010 was settled, that the settlement did incorporate some of the things that had been brought up in 2010 discussions by Judge Provocateur, and particularly with regard to the air rights lease and the impairment caused by the air rights lease and so forth. So that I think that's I appreciate the correction. It all melded in over a 5-year period where this was under discussion. Again, just reinforce, this was, a lot of time was spent on what the right value for Greenwich Plaza was over that 5-year period.
Ms. Moriarty?
Just a clarification, I know that the 2015 valuation carries a 2% discount to the value because of the lease impairment. Was it the same 2% in 2010, or?
No.
So no adjustment in 2010. So how did that 2% impairment in 2015 get developed and valued? If that wasn't by appeal, through an appeal process?
When we settled the 2010, and part of the discussions in the 2010 appeal was that they raised that issue. So in our discussions and in our settlements, when the town created its 2010 assessment, it did not acknowledge or make any adjustments for the air rights. During our settlement of the 2010 appeal, it came, and that's when we were before the judge and what have you, it became an issue, and we decided at that point we needed to recognize that issue. So I did that in the 2015. We ultimately did reduce the value on the 2010 assessment, partly, and exactly how that came out is, it was in part of the litigation.
Mr. Weisbrod?
Thank you. Just let's get back on track here. Just so people know, because a lot of stuff being talked about, the town of Greenwich will own 53% of the office buildings at Greenwich Plaza in 37 years. These office buildings, by the assessment today, are worth $277 million. So, a lot of people say, well, gee, this is so complex. It's not complex. It's really not. The air rights are a euphemism for ownership of the property itself, the buildings itself. These two buildings that are worth today by assessment, and I think probably more than that, $277 million. 37 years, the contract that exists today, we, the people in the town of Greenwich, will own 53% of those office buildings. So we're talking here about values in the tens and tens of millions of dollars. And so I think we want to be careful not to get lost about appeals of assessments. There's nothing to do with it, really. That's not what we're here for. Let me continue with Mr. Branyan, if I could. Do you, Mr. Branyan, recall receiving copies of proposals? And this is in light of Ms. Tarkington's comment about getting expert input. Do you recall getting copies of proposals from Woody Heller, Vice Chairman of Sevilla's Studley, dated January 25th, 2019, and from Michael Chenot, Managing Director of Jones Lang LaSalle, dated December 18th, 2018. These are two very prominent real estate advisory firms. Do you recall that?
Yes.
Do you remember an email that you sent to me with a copy to Peter Tessie, dated March 1st, 2019, where you said you would be reaching out to these two firms for, quote, scope of work for evaluation of the public-private partnership, unquote?
Yes.
Did you, in fact, reach out to those firms?
No.
Why didn't you reach out to those firms?
The timing wasn't right. At the same time that email was being done, we were working with outside counsel at the same time in the infant stage of developing the agreement.
The timing wasn't right. What was the rush on timing? This is a lease that has 37 years left. And, when you have proposals, I'm not saying you have to accept the proposals, but these are people that are experts in assessing public-private partnerships that we are so laudatory about, and you wasn't right. Maybe you can help us understand what it does mean when we say the timing wasn't right.
It was at the time that was presented to me, we were still developing the overall concept of what the public-private partnership would look like, what was on the table from the valuation, what was on the table for the public improvements that we proposed. We were still in the infant stage of developing just the overall concept.
You're in the infant stage, so the timing could have been right if you're in the infant stage. And, it sounds like you could have used a lot of help here. You're using assessed values, which are based on they're called comma massive valuations. You're using an appraiser that doesn't give you an appraisal, that's using some sort of a restricted report that a bank won't accept, based on assessed values that are not even looking at the actual rent rolls, and so I'm really confused. Okay. Are you aware of best practices among innovative municipalities as they pertain to public-private partnerships?
Just before I move on to that, the one point I did forget was we also had budget constraints. The proposals that were presented were, we were struggling with how to even fund the proposals that were presented. I think they had excessive
Did you come
costs.
to the BET if there were budget? We're talking here of an asset worth tens and tens of millions of dollars, and you're saying you have budget constraints. I mean, did anybody come to the BET to ask for an interim, to do anything that would, alleviate that? I'm sure we would have all been accommodating.
I go back to the infant stage, going to the BET without a defined concept of what we're looking at, would have similar conversations of, we'll come back to us once you have a clear defined scope.
So you're
we're
here
not
today, you have no qualm about coming here today and then pushing this into the RTM without any defined concept, but leave that alone. Back
We
to the
have a
question.
clearly defined concept that's been published in July, and we're going through committees and various approval to talk about this concept. This was our administration's recommendation based on the language and outside experts from both council and appraisal. This is part of the process. If we don't believe that the value is appropriate or that it needs to be better, there's nothing stopping the BET engaging the outside experts to evaluate this.
But you're the, I like you, Ben, and it's not, I don't want to, it's not, I'm not trying to embarrass you particularly, but
I like
the
you
issue-
too, David.
I know you do. The issue, which, these, let's move on. Are you aware of best practices for innovative public-private partnership? Have you explored alternatives? It's not about rejecting an enhancement to Greenwich Plaza. The designs that are being proposed look gorgeous in many ways, and there's much to be admired here. This is not what we're talking about today. It's about fairness to the taxpayers of Greenwich and an innovation in terms of how we look at we all love public-private partnerships. Have you considered other forms of public, as opposed to giving away this valuable property? Have you considered other arrangements?
I'm aware of a variety of different public-private partnerships throughout my career. It's a concept that's talked about nationwide, not just Greenwich. There's many different ways you can present the project and fund the project. What we ultimately decided to do was, rather than take cash, and end of the day, cash value that we've come up with said that we have an asset based off the assumptions we talked about, comes in at just under 10 million. On the table, the developer was willing to put in for public benefit improvements 15 million. On the surface, we're saying that's a good structure where for $10 million asset, we can have a $15 million public benefit improvements to an area that will benefit the community. At the same time, by having that type of redevelopment, it allows the administration to have a seat at the table to help frame the conversation on what we would like to see, help coordinate with the planning and zoning, with other various departments on drop-off, pickup. How do you help facilitate all of the other boards and commissions that we have? You can say we don't like this proposal and we want to come back and we just want cash. Cash presents another problem too, is how do you then go about allocating that? We have a process for that with the BET. You can do that. This was our proposal, is rather than just cash, and still we go back to what is that cash number? We believe it's 10. There's other ways that you say maybe present it, but that's where we're at on the alternatives.
Ben, are you aware that New York, we're talking here effectively of selling the land through the air rights. I mean, this is about giving up the land, selling it, future claim on the land. You aware that New York City rarely, if ever, sells its land? Did you know that?
I'm aware of that.
Right. Did you consider alternatives such as extending the air rights maturity?
That was discussed early on with the extension in conversations with Greenwich Plaza, that was not the same level of reinvestment in the area would not have occurred.
Did you consider other alternatives like property tax incentives, even capital grants, revenue sharing arrangements. Any of those get considered?
We've talked about some of those briefly, but ultimately we decided on the town's not in the business of being a developer. The town's not in the business of running an office complex. How do we leverage an existing asset that we have? We thought we put a value to it and then
But-
resolve the issue going forward.
But if
You
you
can
look
present-
at Times Square redevelopment, if you look at Battery Park City, if you look at the 42nd Street Theater, the city of New York doesn't run those projects. They have nothing to do with running those projects, but they share in the future benefits and revenue after a break point. That's what public-private partnerships mean in innovative communities. It's not about running anything. We don't want to run these things. We want Mr. Harvey to run it or whoever it is and make a lot of money. We want him to be hugely successful. But those are what public-private partnerships mean. Thank you.
Okay. Mr. Turner?
Thank you, Madam Chairman. I'm concerned about some of the components of the rationale being used for valuation. I'm hearing a lot of weight being given to the judicial process. I'm hearing a lot of weight being given to our internal valuation and appeals process. And it seems to me that maybe we're making this far more complicated than it really has to be. If I own an asset, particularly something as valuable as Greenwich Plaza, and noting this decision is probably one of the most important decisions that the BET will face historically and maybe in the next couple of decades. I mean, this is enormous. But if I have an asset and someone approaches me about renegotiating the deal, which is really what we're talking about here, I would want to know from a third-party organization what's the best value and be ensured that the approach they used represented industry best practices. Correct me if I'm wrong, but I'm not hearing that today. I'm not hearing anyone say, here's why the town should do the deal as presented, because it represents industry best practices. So I would hope we could get to that, and someone either say, yes, we use industry best practices, or we didn't, and that's one area we need to work on if we didn't. The other is, and I think Mr. Weisbrod made a great point after his trial-like questions. I was impressed with that, Mr. Weisbrod. I think we need to, and Ben, obviously there are a lot of different approaches that the town could take. We need to benchmark the approach. I am sure that what we're up against is, I'm sure somewhere, and in many places, this bridge has been crossed before, and the question becomes, if we are going to take a public-private approach, and obviously we are, is $15 million investment versus $10 million, well, how does that stack up against other public-private partnerships across the country? And I'm sure that data is out there somewhere. So, we've been in a meeting now for an hour. I've yet to hear defensible and plausible reasons why we should do the deal as presented. No one has talked about best practices yet. And when I look at our duty on the BET, at least I can't speak for my colleagues, I've got to have that. I've got to be able to say, here's the reason we should do the deal, and it be defensible and plausible. I don't have that information today. So I would hope that at some point we could address this, and if we don't have that information, let's go back and get it. So anyway, thank you, Madam Chairman.
Mr. Olveni?
There's a couple of things that I would kind of sort of like to correct, and if I'm out of line, please tell me. I've been in the appraisal business for, like I said, 30 years. The other gentleman at the name just mentioned 42nd Street and Times Square in Battery Park City. I worked on half of those deals, okay? 42nd Street, when it was redeveloped basically by the Durst organization and by Forest City Ratner Companies. They were one of my biggest clients in New York City when I worked in New York City. The city of New York does not own any of that stuff.
Does not what?
Does not own any of that.
Does the city of New York share in the revenue after a break
The
point?
only thing that the city of New York may remotely have done at the time, and this is going back to 1990, done a pilot agreement. The pilot
Does the
agreement was-
city of New York share in the revenue of those deals after a break point?
No. To my recollection.
Are you sure about
Going
that?
back to 1990, the answer is no.
Well, I'm not sure you have the facts right.
Okay, the Times Square Towers, the bow tie, those were owned by Prudential. I stood inside one of those Times Square Towers when the parade went by and froze my tail off with my kids. Prudential sold those. I was on the sales team that sold those properties to the eventual developer.
Right. The city of New York shares in the rental revenue of those projects. They are classic, innovative, public-private partnerships. Check your facts, please. Check your facts.
Your information might be
Just check
different
your
than mine.
facts.
Okay. Relative to the valuation of Greenwich Plaza that's done by the assessor, I've sat in meetings with the assessor and the town attorney for tax appeals for the city of Greenwich. As an order of magnitude, at a number that we're talking for Greenwich Plaza of $290 million, that's about $930 a square foot. That's more than any building that's worth in Stamford, Connecticut. There's probably not many other buildings in all of Greenwich that I worked at. The only one that remotely came close to selling for a number such as that on a price per square foot basis is
So we paid you
55 Railroad Avenue.
we paid you $18,000 to sort of put your finger in the air and say, looks about right, because you didn't look at the rent. You just told us you didn't.
Mr. Weisbrod, we're gonna move on to questions about the deal in front of us. There's a question outstanding on the table by Mr. Turner about whether, and I would like to give the town officials, Mr. Tessie, if you'd like to respond now or later to that question. I didn't want to move past it without giving you the opportunity to respond, but I'm happy to move on to other questions since we're running
Well,
time.
and Madam Chairman, let's be fair. So my question is, why should we do the deal as presented, and why is it best practices? Let's be fair. You may not have gone through that process. I don't know, but my point is, if you haven't done that, that's okay. We've got time, but I don't want to. Anyway, I want to have a positive partnering conversation with our partner.
Right.
And again, if
Sure.
we're just not there, we're not
I'm
there.
happy to answer.
Yes, although I think the question really goes to the town side as opposed to Greenwich Plaza side, but I'm happy to, Mr. Harvey, if you want to address it.
Well, only on best practices. I mean, first of all, public-private partnerships encompass many different relationships. We figure we've been in one with the town for 50 years. It usually involves a private entity in some capacity providing a public service. Since we own the train station, since we share in the parking on the commuter side, since we have the drop-off, the pickup, and so forth, we're in effect providing a public service as a private entity. What we did with the town, what we did on our end, was spend some time looking at Urban Land Institute, real estate, public-private partnerships. Not all public-private partnerships are real estate, so we spent time on that, went to seminar, got the published materials from ULI on the best ways to partner to set up a successful partnership, which we shared with the town, all the information we had on that, and the two things that they said were probably the most important when you're trying to set up a real estate public-private partnership are to be sure that both sides, particularly the public side that doesn't deal in real estate all the time, is properly represented by counsel. And having experienced counsel is absolutely number one. And the second thing they mentioned was very important, again, particularly from the town side, to have outside appraisers involved, and that the appraisals had to be very well prepared and understood, particularly in a public-private situation, that was absolutely best practice. And we have appraisals from two of the top real estate firms in the United States that do this nationally and globally. And our appraiser is Jim Moran is here, who from Cushman & Wakefield, one of the most prominent appraisers in the country. And he is here also to answer questions on best practices and appraisals also. So that was what we did, and I tend to agree, once you really get down to this, I tend to agree with Mr. Weisbrod. This is really about the valuation, and you have to understand the present value concept, because numbers 50 and 100 years out can sound astronomical, but if it's complicated to get to them and the rate of return you want to get there is relatively high, meaning a reasonable discount rate, the number that you end up with today is surprisingly low, and I understand that completely, and we addressed that at the RTM, and that's one of the reasons the appraisals are so important, because all real estate now is basically traded using appraisals exactly like these billions of dollars invested by real estate companies and lenders loaning multiple billions of dollars based on exactly these kinds of appraisals. So for the public-private partnership for best practices, you should have really outstanding experts that were brought in, and that's we brought in our expert, and the town brought in theirs. We still think ours is correct, by the way, and Mr. Moran is here to answer questions along with the town's appraiser, Mr. Olveni. So we had two appraisals, in effect, done by prominent outside firms who represent all the named developers, lenders, and so forth in the United States. So that was the ULI approach on best practices for public-private. But then getting into the valuation, why the town should do it, that's not really for me to say, but that's how we approached it from the beginning with the town.
Yes. Ms. Tarkington.
Yeah.
First, is there a chance that I could have our expert, who's
So,
far more articulate on this than I am, who came
We will,
out today?
and we
to
appreciate
talk?
that. We'll come back to it. I'm going to have
Would
Ms. Tarkington ask the question. In truth, from where I sit, and I give you due deference for your commitment to the town, but the developer's motivation and interest is a different motivation and interest than the town's perspective, and I'm
That's
sure he is an expert in his field. However, he's not representing the town.
No, but
Right.
his name is on the appraisal, and it's his reputation
Yes,
out
and
there.
right. So we will
If
come
you can
back to it.
If you can come back to him, that'd be great.
Absolutely.
First, I had many questions here, but I thought originally we were working off of David's. The discount rate, quite frankly, the discount rate, whatever, 10% or whatever, you mentioned, is very high for the town of Greenwich. I mean, the discount rate should be your cost of capital, and which represents both debt and equity. So, that may be fine in a private development situation, but certainly not for the town of Greenwich. In our case, I think we would be using the cost of debt. Otherwise, we can issue, increased taxes through our, mill rate. And so our cost, we need to refer to our Chief Financial Officer, Pete Minarski, and find out what, tax-exempt debt rate we should be using rather than these higher rates. I think that's, critically important. This 2% declining value, the question is the value really declining for us, or is it only declining for the developer? So, I do think that needs to be questioned. Air rights. We've moved air rights, and then all of a sudden we're talking about New York City, et cetera, et cetera. But I have, and by the way, there are many land leases in New York City, whether it's over the railroad or whether it's along Central Park South. There are other examples there. But more importantly, I think the question here is, we use FAR in the town of Greenwich. But I believe, and I don't know, I have not done this work, I'm not this is just one of the many, many projects we have. We had commercial zoning at that point in time, but did we have FAR? And I don't know. I think that air rights sort of stood for FAR before we began to go through that process. And, it's all kind of, I think that someone needs to do this work, and perhaps that's our land use lawyer. Again, I'm very concerned that we have land use lawyers here and no real financial attorney. I think that is not doing a service to this board and the town of Greenwich. I'd like to come back here. What do you show as total assets on the audited financial statements for GPI? I'll ask Mr. Harvey that.
We were asked this at the a meeting with the value.
I didn't attend.
The valuation of Greenwich Plaza, the fair market value, which is what we're talking about today, which is what it's worth on the outside market, which is what the town assessor deals with, and was the number that we started out with for making for arriving at the value, as opposed to, that's why the discount rate is there. It's what a real estate investor would pay for the product. That's what the appraisers were tasked with, is not figuring out the town's cost of capital, but figuring out what a real estate investor would pay. What's the fair market value for the property? And a real estate investor doesn't buy much at a 2 or 3% return, because that's the risk-free rate, and the rate on real estate, particularly a complicated real estate deal that you don't really realize much on at all until for 30 or 40 years. They want more than a 2% return for taking that risk. In terms of our what we value on our financial statements would not be of any help to you, because it's depreciated cost.
I understand that.
So we take so it has nothing to do with fair market
And so you have
value.
you have no
So
market.
it would be a number that would that you would probably laugh at in terms of what the value is, because it's been reduced. Fair market value is not used for GAAP for financial statements.
And do you use the market value? Isn't there a market value footnote that has to be there?
I'd have to look at whether I doubt it's in the footnotes. It would be, because then you'd have to have had done an appraisal for that particular financial statement, and the appraisals aren't done all that frequently. But it's the financial statements of our company. We're a private company. It's one of the benefits of being a private company. But what this property is worth is based on what current market rents are, which are not a secret, what it costs to operate an office building like this, as Steve was saying, is not some secret. You can talk to brokers, you talk to what recent buildings sold for. There's an awful lot of discussion going on, and at $900 or $1,000 a foot compared to other buildings and so forth. I'm not trying to make anything sound secretive here, but the brokers know the deal. They know whether you have long-term leases under market. They know what the current market value is. As the assessor said, she knows what and finds out what current market values are. You got your operating expenses, and you know what comparable properties are selling for. So I realize there's a lot of people here talking. This is not some big secret what this property is worth, and so we're not. There's nothing being hidden on what the value of what this asset is. There's plenty of
So,
of
Ms.
evidence
May I
of
just finish then? Who are your outside auditors, please? You didn't answer my first question.
KPMG are our
Okay,
outside
great.
orders.
And, again, in a partnership, and I've been involved in many of them over many decades here.
Ms. Tarkington, is there a question? There are a lot of people with questions, so please get.
Okay, I just, again, I've asked for the financial statements. I think the town deserves to see the financial statements if the town wants to be a partner in this. I would also just like to add one thing. In our last meeting, I think this is like a mixing bowl. I mean, I've never seen a transaction like this in decades. We've got a real estate transaction. We have, which is really the north side, one parcel. We have a separate real estate parcel on the south side. And we have a capital lease. And I think in order to proceed and really work together, we need to separate these pieces. It's like putting everything into this mixing bowl, a capital lease with its ingredients. So all these, and turning on the motor, and everything goes flying.
Okay.
We need to define this better and then work together to resolve how we can work and move forward. And
Thank you, Ms. Tarkington. We're gonna work together and let our colleagues have some airtime. Mr. Mason?
Somebody said there's a devil in the details. I think we have the whole devil's family here. Let's see, how do I start? Because I haven't gotten over my August 9th question after a series of emails between the BET and the town attorney saying what we could and couldn't do. So I think we're into the details, and I think we're skipping chapters. And let me just see if I can put a perspective where I think the town needs to start. At the end of the current agreement, I'll call it an agreement lease, license agreement, whatever you want to call it, there's a question, does Ashworth own afterwards? Do they own it afterwards? If yes, maybe it might be better for the town to accelerate and sell now rather than wait. And that's where we'll have to get into the question of assuming the value and coming up with a value that we think is fair and marketable and all the details. If not, if they don't own it, then I haven't seen yet the reason to sell an asset that we know is valuable today will be valuable tomorrow, or more valuable tomorrow. And what other options there could be if we don't want to sell it. Could we renegotiate the current lease under new terms? Could we do something like that? I think once we determine which way we want to go on those two avenues, then I think we can get into the, call it trials and tribulations of how it's valued and what we think the values are. But right now, I think what's before us is what's the best option for the town? And there's probably a third option is to do nothing right now, but there seems to be a demand for that. So I think step one is we have to decide which route we would like to go. If we own the asset at the end of the current term, I haven't heard a lot about renegotiating the current. If we don't own it, then we have to do the math and I give everybody high accolades for the work they've done in this. Then we have to get into the conversation about the value, how it's valued, how it will be valued, what we think the future value is. So that's just sort of my perspective I think we ought to try to address.
Okay. Ms. Hess?
Hi. I'm not going to get too much into the merits. I do think that there's still some open questions, but just some things that have been said that, from my experience as a real estate investor, I just want to point out. So fair value is, what is fair value? It is the value between a willing buyer and seller. And so what does that mean? That means that a buyer is definitely not going to buy an asset at the seller's cost of capital. They're going to want a rate of return. So I just want to reiterate that point that no one would ever buy this asset at our rate. I mean, just based on how it works in the real estate business. In terms of just adding on to Ms. Tarkington's point about financial statements, you would never do a fair value for real estate unless you were following investment accounting. Only financial assets have fair value. So while I do think it might be helpful to have financial statements, we just need to be careful about what we're asking for and make sure would it really truly be helpful for this. I do think there's a number of open questions here that we need the answer for, but I just want to make sure that when we're talking about some of this stuff, we're clear about what it is that we need and how it actually works in the finance world.
Mr. Raymer?
So just some points in overview. I think the questioning by Mr. Weisbrod made it very clear that there's a lot of relevant fact that we do not yet have at our disposal, that for us to make a prudent business-like decision, we'd want to have at our disposal. Among the remarks, in addition to the very incisive questions from Mr. Weisbrod that I thought maybe are worth just passing observation, is that the comment was made that we would acquire at the conclusion of the lease in 2057 or 2037, depending at which point it concludes, are 53% of the buildings. That's actually not quite correct. We would acquire 53 and a fraction percent of the land. We would acquire all the improvements that overstand the land that we're acquiring. I have no idea what that is, but to glance at the schematics of the location of the buildings, to look at the survey of the property, which is exhibited, it looks as if by footprint only, the majority of the buildings actually overlie the portion of the property that the town would then be owning in fee. What does that constitute? I don't know. You'd have to understand the value of the equipment and assets that are inside the buildings. A very strange circumstance at that point to be owning the back half of a pair of buildings. It's not as if we're tenants in common or something. It's just a very bizarre circumstance. But the 53% of the buildings is not a correct statement. Secondly, what's proposed here is not a sale of the land. It's the sale of only the air rights. We would remain, of course, the owner of the land. Maybe that's a good thing, maybe that's a bad thing, but I surely want anybody in the room to understand what's being proposed here. We're selling the air rights. Both of the appraisers, both CBRE and Cushman and Wakefield, commented in their appraisals that this arrangement, the ownership arrangement, is very strange. And that because Mr. Turner spoke about benchmarks, there aren't a lot of benchmarks out there because the deal is very strange. I would have to defer to the people who are expert in this to understand just how strange, but certainly that appeared in both of their appraisals. Just to throw a figure out, not that has much relevance to anything, but the assessor was asked at one point, what's the present value of the property today, meaning the entire piece of land owned by both the town and Ashforth and the buildings on it, if you were doing it in the way exactly that the assessor described, using the mass model, et cetera. And the figure that was put forward without the 2% reduction for the bizarreness of the deal was about $294 million. That doesn't actually represent what the present value is or what the town owns or something. I'm not suggesting that. I'm just trying to give you an order of magnitude for you to have numbers in your head as you try and weigh where these things are going. So it seems to me there's a few things in the overview. First of all, I think our position right now is that it's premature to try and make a judgment for all the reasons that Mr. Weisbrod was so clearly focusing on in his questions, and that is we don't have facts at our disposal, and all due deference to both Mr. Moran and Mr. Morrison, I don't think that that we've really had the advice from people with the development expertise to understand the deal, because the deal is not quite just the legal issues on which Mr. Morrison has been advising us. It's also not quite exactly the simple appraisal issue of the property which Mr. Moran has been advising us. It's a little beyond that, and so I think Mr. Weisbrod's point of, gee, we really haven't gotten the expertise that we should have gotten to help us advise us, I think that point is very well taken. I do think a couple of further things need to be said. I don't mean to be echoing things that Ms. Darkington has spoken about, but this is a marquee property in town, and I think the town has a vested interest in seeing this property be happy and prosperous. I think it also needs to be mentioned in passing that we've had a very pleasant relationship with Ashforth as a partner. Not that that should change the dollar figures at which we do things, but I don't want to lose sight of the fact that we've been working with a very pleasant partner, and we're grateful for that. I personally don't know that others will share my view on this, but I would rather have seen an arrangement in which we had sold everything, including the land, retaining the ability to maintain the parking for the benefit of the town, so that we could begin to extract ourselves from this oddball business relationship. Because if we continue to own the land afterward, two things happen. One, we're in the business, sort of, in real estate investment, development, and management, none of which is in the skill set of what the town does well. Secondly, we continue to be trapped in this arrangement of there's a maturing date at the end and a very bizarre arrangement that I'd like to see resolved if this is the moment to resolve it now. Now, all those things are just my personal point of view. I'm only one member of one body.
Mr. Raymer, is there a question?
No, I'm sorry.
Okay.
I was making a statement.
Okay.
Can I comment on one thing quickly?
As I want to do.
Okay.
But my
Do you
statement, you'll
have-
be glad to hear, is now finished.
Thank you. Mr. Mr. Harvey.
Just thank you, Mr. Raymer. A very quick comment. The redevelopment agreement does provide the continuing use of A level for the town, so that property continues to be used by town, and there would be a perpetual easement forever over our property, so that A level, that issue would be resolved, and that was part of the redevelopment agreement, trying to make sure. That was an easier one to address than the...
So we are just under an hour left. I'd ask my colleagues to limit their statements to questions so that we can have the opportunity to allow our guests to ask questions as well. Ms. Moriarty.
There's been a lot of discussion about the valuation of what the town is giving up in this process. I just wanted to raise the other side of the equation, is the valuation and the both cash as well as qualitative of what we are being proposed to get in the transaction, the redevelopment of the north side and the easement access to the municipal lot. When we look at the redevelopment of the north side of the property, while as proposed, you're indicating the town would get benefit from a greater facility and a upgraded train station, the parks, and then the access on the north and the south side to the train station improvement. But it's also fair to say that Ashforth gets a benefit too. You're getting an improved facility. The town would get the benefit of the property taxes on an improved facility. However, that's true with every development in town, that, you have an incentive to invest in that property and improve it, and that's part of the decision-making process here. Can you tell us what the obligations are for Ashforth to provide a station or an access to the Metro North tracks? You're one of the few private ownerships of that right.
Sure.
In the state.
Well, a couple of parts to that. We view it as whether we're incented to make a long-term investment that does benefit, we believe, the whole area. I've had conversations with the office building across the street, who will be putting nothing into this, but is very excited about having a beautiful new project across the street and retail and improved and so forth. So it does lift all boats, and we're one of the boats right there. I think technically he's actually closer to the north side development than we are because we're on the other side of the tracks. But we do, everyone does benefit, and I actually looked at office buildings, just office buildings within about a mile and a half of the station, the large office buildings and the grand list. They pay about $10 million in taxes a year. So if the overall transportation center helps office buildings in the area either 5 or 10%, it's $500,000, $1 million more a year in taxes every year if it's a more attractive place for people to get to and from. The other part of your question is on our obligation now is contained in a deed from when we bought the property from the railroad. We had to build a certain size station. We have to have a ticket booth in there for that's why the ticket booth is still there. It's still required, even though Metro North has said they don't need it anymore. One of the nice opportunities here is to be able to revamp to a modern station to reflect what Metro North needs compared to what the railroad station required 50 years ago. So we're meeting that obligation fully. Right now, we maintain the station. We think it needs some cleanup, but we also think, for a variety of reasons, which we've talked about at length with P&Z, in terms of the role of rail travel in the future in this area and in Connecticut and the New York area, this is a tremendous opportunity if we're going to do something to this station, and we're being encouraged by Metro North and ConnDOT to do it, to really make this an exciting transportation center. But we're meeting our current obligation, which is, and we have no obligation to provide anything on the south side, and we also have do the pickup and the drop-off isn't well established there. There's something in there about an elevator. There's something about size of coffins to get them up into the train. I mean, this is 50 years ago, and it was pretty small size of the station, sort of size of waiting room, and that sort of thing. But that's our only obligation, which we can meet, and we'll keep it upgraded. If we're not incented to make a long-term investment on our property because of the uncertainties that I've explained in the big picture ownership, we can just maintain it pretty much the way it is, functional. And I've had people say, I love the station right now, and no need. Why are you thinking of improving the station? Well, what we see for rail travel in the future, and what Metro North and ConnDOT sees, they're very excited about the Greenwich having a train station that represents a modern train station.
What I wanted to confirm is, as you think about redevelopment of that property, and let's say this transaction doesn't develop the way that you'd like it to, what your minimum requirements are and how that could impact the residents.
Yeah, and the minimum requirements are being met right now. We don't have to do anything more, in our opinion, than required. It's pretty simple. And it was mainly focused on building the station because it was quite a change in a new structure 50 years ago. So a lot of it was about building it, how you operate it while you're building it, and so forth. It was more on that than looking out 50 years.
Two other
would be.
questions.
Sure.
When it comes to the redevelopment of that property, and may move a little bit more into the P&Z, but it gets into the valuation of how you valued what you're providing to the town, the park. But your proposal for that north side redevelopment maximizes the FAR of that, so you really couldn't build something in lieu of a park. You may not have to outfit a park.
The technical answer is we could,
Okay.
because we could, the main restriction there is the parking. So if we took down the theater, I believe we could allocate some of that property to parking, therefore meeting the zoning requirements on that. This is really a P&Z question. And have a bit more retail there, which we'd be able to provide the parking for when we took down the entire theater
Thank you.
structure. We think a parking lot and the retail there is, we've been encouraged that the town would really appreciate having an open space there and having the public park and better access up to the train. This is really. We're having another P&Z presentation next week, so anyone who wants to get into hearing the revisions, how we're responding to the latest requests from P&Z, be there on the 26th. On the 26th next week.
The last question.
To talk about how we're responding to the comments from our last P&Z meeting.
The last question I have may be more to Mr. Branyan, but in terms of the valuation of what the town would be getting in the transaction, the valuation of the public benefit of the redevelopment of the north side is based on construction cost. Can you tell me what alternate methodologies municipalities use in valuing the public benefit of investments?
We tried to address that concern in two ways. The first is we entered into a side agreement where when it's ready, and we have not done this yet because it's still being, I'll call it tweaked from the P&Z perspective. Once a solid plan is presented, we'll have an outside expertise that's working on the town's behalf to do the construction evaluation piece of it. In the agreement, at the end of the project, if it goes forward, we'll also have our own independent expert that will do looking at the actual construction cost and the allocations for some of the public space. I'll just pick on the concrete trade. When you purchase the concrete trade, it's going to be an allocation between, is the concrete going here or is it going to the park? We'll have our person that will take look at that to make sure that allocation is being done in the best interest of the town. That'll true up the expenses, and at the end of the day, if the actual investment by Greenwich Plaza does not fall short of the $9.9 million number, there's a provision in the agreement where the difference has to be made up in cash to make us whole.
The issue I'm raising, and I'm not an expert in this area, is whether construction cost is really how you would value public benefit. And I have questions on whether that's certainly can't be the only methodology, but whether that's the best one in this case.
Right now, it is the best one. I had a conversation with our outside group, AECom, and their division that does this, and done quite a few for the state of New York. And this is the best for the cost allocation piece and where we're at. This is the best practice going forward.
Yeah, and that raises the other question. It's related to the question of the town is giving up an asset, giving up a cash flow. We're retaining an easement right or getting that also in perpetuity, which has value to us in the municipal lot. But whether what we're getting in return being this perceived public benefit of the redevelopment of the north side and then the property tax revenue that we would be entitled to anyway, whether that really is the fair cash transaction, if you will, for the deal.
I thought she was addressing it, but I do have one additional thing.
Mr. Harvey.
Sorry. The one I was talking about with the whole area being improved, which is what P&Z really is, that's really their function, encouraging a type of development that they think helps the town. Turning that into the dollars, it gets into more like soft dollars in terms of if the whole downtown of Greenwich actually becomes more attractive and there's further development, encourages other stuff. there are people who come in and do estimates, but by definition, they're somewhat soft. But TOD developments are accepted now that improving transportation in areas does add value. So that would be another methodology. It wouldn't get you to hard dollars. The other thing that we will be providing once we know, assuming this happens, once we know what we're building, if it's a new station that'll be more complicated to maintain, if it's a new south station that isn't there anywhere anymore that would have to maintain, the fact we will be giving up the taxi stand as part of building the new station on the south side, there's significant income that we get from that we would be giving up. The drop-off and pickup that we'll be maintaining. And then the park, maintaining the park in perpetuity is a number that we think we can actually make into sort of a hard number. What's the value to the town if they like these facilities that we will be, as a public service, will be providing maintenance in perpetuity for those? We can actually think we'll be able to put a pretty hard number on that, so I'm just trying to think of other ways that you might measure what the benefit to the town is. But I think by far the biggest is the town think that this development is consistent with the plan of conservation development and so forth, and consistent with what the P&Z would like to see new development look like in the town of Greenwich. And then very hard to put an exact number on what that result is.
Thank you. Ms. Vasiliotis.
Thank you. I want to thank you for including the BET in this discussion. I know that, per town charter, and we really don't have the authority to consider the lease. It's really up to the RTM. So I want to thank you for including us. If the town bodies...
Can I have point of order on that?
No, we're just going to let her finish the question.
If the town bodies were to reject this deal, what alternatives would you be considering? Would you be doing nothing? Would you extend the lease and redevelop? Would you consider the town selling the land and the air rights outright? Would you be amenable to any of that, or do you have any other alternatives? Or what would be your plan if the town bodies reject this?
I think, top of my head, you pretty much covered most of the alternatives as you listed them. Immediately, as I said, the building, we're keeping it together for the theater. The theater probably goes. I mean, that's it. Whether it makes sense to make a massive investment on a second floor multiplex new theaters on the other end of the property without doing the rest of the development is something we'd have to decide. That's a very long-term investment. The initial, it's be one of the most expensive theaters built that you can imagine. But we think in the long run they probably are successful. But it's a tough call as part of this overall development and creating a whole new complex down there with better food, entertainment, so forth. Particularly for millennials, we think makes a lot of sense. But to answer your question specifically, we would come up with a new use for that space where the theater is. We would continue to maintain the station as we're obligated to. We'll leave we will not be making significant investment on the south side, either with the new south station or the moving of our visitor parking, so we can create another lane for much better drop-off and pickup. And we would consider keeping using the building that the taxi stand is in for some other purpose, which would provide income for us until down the road this gets worked out. Because I view it as the judge said, you're kind of in a lose-lose situation here. If we're incented not to maintain this property, and half of it, or to correct, not to correct, I think the number, Mr. Raymer, is somewhere around 57, 58% versus 53% if you take the actual floor area of the building. And it's crazy to even consider, and taking a minute on this, is that this deal is so crazy, as you point out. The towns would have the view, because it's the southern part, but the northern part has the access to the train and the parking lots. So if you own just the south half, how would you get to your property? Do you build new parking ramps up through the half that the town would have on the south side? You have to get through the Ashforth side to get to the south side. You got HVAC systems and so forth that are operating both. You got to have tenants. Eventually, there's just not an incentive to invest in it. which means the real estate taxes go down, the value of the property goes down. So if you waited till the end of the lease, what the town would be getting would be probably pretty decrepit because you couldn't finance it and you couldn't lease it. So there'd be pressure on people eventually to get this resolved anyway. So you kick the can down the road and leave it. But we're hoping a sign of really good governance to us is people who are able to look forward.
Yes, I know.
Who are able to look forward and anticipate it. But I think that, and we'd be open to, if the town didn't like the development and was talking about a different deal that was pure cash without the, we need to try to resolve the uncertainty so that we have the incentive to continue to invest in the property, and we're open to anyone who's creative. We're willing to listen to anybody who, as we've invested a lot in this particular attempt to do this, a significant amount, frankly, with a number of different plans back and forth with the P&Z and to get to the point we are today. But we would, does that answer your question?
Well, I guess my question is, would you be interested in extending the lease for another 50 or 100 years or whatever it is, which would give you the security to know that you still have the property and whatever you're doing with it, and then also do the redevelopment? Or is that something that's off the table?
Well, there are situations where if an extension is long enough, it's the equivalent of owning the property. But the way this works is with about 40 years or so left on your lease, you start running into issues with financing and so forth. And we it's certainly not intending to put in improvements that are in effect the value of paying for the air rights lease and then also leasing them and paying rent on them. I'd probably be advised by my group that's not very smart. So but in terms of
Well, you'd have to see what the deal is on the table.
the long term, I'd have to say that super long-term leases, but they have to be very long because lenders and real estate investors are smart and they look down the road that at about 40 years, it starts impacting the value of the property. We had research done on this, and this was part of our discussion with the assessor and the judge who agreed with us, saying this ought to be resolved. The longer you wait, the more it's sort of a lose-lose situation. The sooner you can resolve it, the more we're incented to invest, and we think it becomes a win-win. And as I said, I think being able to look forward down the road and find a way of resolving this very odd situation, as Mr. Raymer pointed out, is beneficial to us and the town, and we're kind of locked in this together right now. So I really appreciate your question, by the way. Thank you.
Thank you, Mr. Harvey. Mr. Hess, do you still, Mr. Deuce. You still have a question?
Yes. Following up on Ms. Moriarty and Ms. Pasiotis, we have two big unknowns here: the value of this asset that we own and the value of the improvements that we'd be receiving in return. And this strikes me, many people here as well, that our cost of capital, which alluded to earlier, is 2-3%. Yet we're using an asset that's being discounted at 10 to finance an investment at a much lower return. So I asked the question: can we unbundle this? In other words, separate the sale of the asset from the purchase of the receipt of the improvements. Give us a cash option, for example. And I have a separate question. There's been lots of experience, certainly in New York City, with long-term ground leases, and this can't be a new situation where you're coming close, say within 40 years of the expiry of the lease. There must be lots of experience with how you extend these leases. And I thought what Mr. Weisbrod had suggested earlier makes a lot of sense. That can we add, or as Karen also added, can we add a 50-year extension of this? That gives you 87 years to go, and certainly, no?
Only because with about 40 years to go, you're in the same place. So you end up back right where we are today.
I think the battery went.
Is my battery up? Not yours, but this microphone.
Mr. Deuce, okay.
That's fine.
So I'm going to I hate to cut off debate amongst my colleagues, but I do want to give the opportunity to the public who are here to ask questions while we have so many representatives of both the town and of Greenwich Plaza here. So I would just ask, if you do want to speak or ask a question, please limit yourself to questions and not public remarks. Please identify yourself, and I open it up. I'll happily share my microphone. Mr. Anglin.
Hi, I'm Joe Angland. It was noted correctly that the present value of $1 40 years from now is a lot less than it would be then, but the amount less it is depends upon the discount rate chosen, which was an issue raised by a couple of people. I'm not going to inquire about the propriety of the 10% discount rate, but rather the sensitivity of the bottom line result to the choice of a discount rate. I was sitting here without a computer, and therefore I could well be wrong, but my quick math said that if you chose, for example, an 8% discount rate rather than a 10% discount rate of a value 40 years from now, the value would increase to about 250%, between double and triple the estimate that you have with an 8% rate. And that if you use a 6% rate, it would increase to about 600% of what you would get of a 10% discount rate, so a multiple of 6. Again, I didn't have a computer in front of me, so I'm not positive, but I'm just wondering if anybody on your team can indicate whether those numbers are approximately right, and if not, what the real numbers are. Thank you.
No, you're absolutely right, and in my head, you're not far off with the math. You must have some sort of a mathematical background or something, but it is very sensitive to that. The example I use is that, which I figured out, $1 million in 2057, 38 years from now, discounted at 10%, is worth about $26,000 today, $26,500 to be if you were going to invest it at 10%, because that's the rate of return you wanted on this type of investment, but given the riskiness of as Mr. Raymer was pointing out, about what the heck do you have at the end, and you wouldn't want to sit for 2%. The initial return, of course, is just the existing rent, which is about $200,000 a year, and that's what you get for quite a long time, and betting on what it will be at the end. And you want a pretty good return if you're making that bet versus putting your money somewhere else. What I'd really like to do is use this as an opportunity, because I'm not the expert on this, on the discount rates, but let Mr. Moran just have a few minutes, as you said, Chairwoman. I've learned a lot from him. He's the expert. He was also involved when we were talking with the judge about the air rights lease, going way back and doing a full evaluation of the impact of air rights, which addresses the question on how long an extension you really need to be able to address this issue. But if I can get him to come.
That's fine, and if you could respond to the sensitivity analysis as well.
That would be mainly what he does.
Good morning, and thank you. And I'll try to be brief, although every time I say that, my wife shudders, so I'll do my best.
All right, well then I'm going to exercise Chair's prerogative.
So a couple of things. First of all, to be very, very clear, there's been comments made about, well, I'm the developer's appraiser and Mr. Mulvaney is the town's appraiser. We're only advocates for our own value. We're not partisan. We don't advocate for a client. We advocate for our value conclusion. So we are third party. We're independent. We're unbiased. We're asked to appraise market value. That's our charge. That's our goal. That's what we do. Excellent question regarding the use of a discount rate and how it's supported. There's several methods for establishing an appropriate discount rate. Most of it relates to risk. If you had the opportunity to look at our appraisal, you'll see that the analysis, and your question, best practices, absolutely a great question. The valuation of a property like this is based upon the ability to receive future benefits, which in the case of Greenwich Plaza is income. I'm going to receive certain cash flow, and at some point in the future, I'm theoretically going to get another benefit. In our approach, we bifurcated the two components of the return. The first being the rent, which we feel is very secure. That's going to be paid as long as Greenwich Plaza is operating the property. They're going to continue to pay the rent and not be in default. It's a very riskless position, in my opinion. That's a rate we apply to that cash flow rather, we applied a lower risk rate of 6% to the cash flow. You look at the reversion, and as I think every party here has agreed, the circumstances of the lease and what happens at the end of the property are bizarre. I think was your commentary. It's unique. As part of the analysis we've done, and by the way, I've been involved with this air rights impairment testing over 4 years now. I've researched the country and I've researched through Canada. I've not gone global. This situation does not exist to the best of my knowledge, and that is the fact that at the end of the lease term, the physical improvements themselves are split. Doesn't make any sense. I think Mr. Harvey articulated what exactly happens. You get some of the views, but you can't get to it. Well, what is something worth if you can't get to it? To the reversion, we applied a very risky rate. I think it was 11 or 11.5%, something like that. As a test, and I think you'll appreciate this coming from that background, as a test, we then looked at what is the total return, what is the internal rate of return that might be contemplated. We tested that, and we came down to an internal rate of return slightly higher than Mr. Mulvaney, somewhere around 10.5 or 11%. Our opinion is that's a rate that's representative of the combined risk associated with the cash flow, which we think is very low, and the risk associated with the reversion, which we think is very high. And the closer you get to the end of that lease term, that risk premium would increase. In other words, if we were asked to look at this property 10 years from now, the risk premium associated with the reversion would be significantly higher.
Thank you.
Hi, I'm Mary Flynn, and I'm on the RTM, but I'm asking questions for my own knowledge. Can you explain to me how exactly the property is owned? I heard you say that you bought the railroad station from Metro North, and that a portion of the parking lot is owned by Ashforth. Is that correct? And the rest is owned by the town?
I'm sorry, I couldn't get the whole question while I
Okay.
was.
Can you explain how the property is actually owned, the
Sure.
land? Because I heard you say that you purchased the
Yes.
station from Metro North and that you own a portion of the parking lot. So how does,
Yes, actually, this is all on the town website with
It is?
maps.
Okay.
We didn't bring them.
All
the
right, no,
maps,
I
but
can look
if
there
you think
then.
about it as strips, there's a strip running across the, we have one? Oh, good. Thanks, Ryan.
Thank
Thanks very
you.
much. There's a strip along the north side here, which is where the theater is and so forth.
Okay.
That we own ourselves. Then there's parcel 2 here, where it says parcel 2, the thick black line. We own that. We originally owned the inside of all that dotted line there, but that's another story that relates to the rent and so forth. We transferred that for no consideration, except as part of the overall deal back in '67 to the town. So that's why we don't pay rent on that center part. But the town owns parcel 4 at the bottom here, so you could think of it as sort of 3 strips with the railroad in the middle. We own it, the town owns it, if that helps. And the buildings are both built over parcels 2 and 4, and that's the confusion.
so you own panel 1, panel 2, and tract 1?
We did own tract 1, but that was conveyed to the town. So the town basically owns tracts 1, 2, and 3. They originally owned 2 and 3, and we added 1 to the ownership of the town as part of the initial transaction. Those parcels, parcel 1, 2, and 4, and 3 is still the railroad.
Parcel 1, 2, 3, and 4.
Yeah, and so 1 we own, 2 we own, 4 the town owns.
Okay. Okay, so you actually own the station. Isn't that
Yes.
unusual?
Yes,
Like
we're
for-
one of 2, I think, in the state.
Okay, okay.
And I can't
Like
remember, no one
public
seems to tell me
access
who
and
the
all
other one
that,
is.
You know?
What's that?
I mean, it's like public access and all that, so it's all easements
But
that you have.
Well, we have an agreement to maintain it from the deed. We're obligated under the deed to maintain it for the railroad.
Right, for the railroad.
And and that, in effect, for the public, right.
Okay. Ms. Flynn, do you have a
Thank you.
specific question?
No, I just didn't understand how the
Ms. Stretcher.
private part could own
Right.
the land and then, okay.
Thank you. Ms. Cruiser?
Good morning, Miriam Cruiser, RTM District 7. Again, question on my own behalf. I wanted to go back to Mr. Moran. Mr. Moran, don't go very far away.
Mr. Moran?
Question for you. No, it's okay. Question for you. Wanting to go back to those discount rates. So my understanding is that unlike CBRE, that you have the two discount rates. One, right, the 6% that you view to be less risky, and then a more risky 11.5% for what you call the reversion.
Correct.
I could understand from a third-party player who was coming to look at this deal and wanted to purchase what Greenwich currently owns, that 11.5% making intuitive sense because, in fact, that is very risky for a third party. What I'm kind of trying to wrap my head around is for Ashforth, doesn't this actually reduce the risk to their portfolio, i.e. because they're already a part of the deal? Isn't the fact that they would then own the entirety of the construct actually reduce their risk? And so shouldn't it be 6% across the board?
So it's an excellent question, and I think there's a distinction that needs to be understood between investment value and market value. And I don't recall who was addressing cost of capital. It's Harkin. Sorry. It may have been you earlier. Is this working? Yes. That one's working. Okay. There was a question regarding cost of capital. Well, each of us in this room has a different cost of capital. I certainly can't borrow at the cost that the town of Greenwich might be able to borrow at. And each of us would have different circumstances, different interest rates. So investment value is the value to a specific entity, whether it's the town of Greenwich specifically, whether it's the Ashforth Company specifically, whether it's Jim Moran and Steve Mulvaney. Our charge is market value. So that's the universe of investment values, if you can sort of get that picture. In the universe of investment values, the market value that would be concluded to would look at this under best practices at the risk associated with each component. What's a view premium worth to you versus what it's worth to me? There's going to be a difference in what we think is a view premium in a residential house, or as an analogy.
I guess as a follow-up, would this valuation look any different if it weren't for Ashforth? I.e., if it were ABC Development that came into the town of Greenwich, would the value that you put as part of your appraisal look any different?
What would ABC's position be? What are they?
If they wanted to take over Greenwich's, so if we had another party come in and wanted to take over Greenwich's ownership structure as part of this lease,
Correct.
would the valuation that you put together look any different for that party?
The market value would be identical.
Okay. So you're saying that even though Ashforth is a party that actually can change the variables, i.e. go to the assessor and ask for them to reduce by 2%, even though they can change the variables, their risk is no different than a third party as part of just the mathematical assessment of the situation?
That's absolutely true, on a market value basis. Yeah.
Okay. Ms. Hamry?
Hello, Marita Hamry. I'm a member of the RTM. Just trying to understand and clarify the relationships. And as I understand, Mr. Mulvaney represented the town, and we paid your fee of roughly $18,000 for that. Mr. Moran, your fees are being paid by, I assume, by Ashforth. And are you at liberty to say what those fees are?
If I recall, again, I've been working in different capacities with Ashforth on the air rights issue since 2015, I recall. So each piece has been a different fee. Don't hold me to it. I believe our fee for the air rights analysis was $8,000.
Ms. Von Brockel?
Hi, my name is Lucy Von Brockel. I'm an RTM member, but asking this question for myself. I'm curious about the valuation of the public benefit, because as you said, Mr. Harvey, the building across the street benefits from the train station and the park and the stairs. So how do you not also benefit from that? How is that not factored into the overall valuation at cost of construction, it doesn't really make sense to me, because you do get something out of that. Why wouldn't you update the station if it does benefit real estate values for you?
Well, it would update it. It would increase them if I knew what the long-term ownership situation was going to be. And so for us to invest now, hoping that this gets worked out at some point in the future, because the initial valuation, particularly with P&Z, we aren't getting, as you often do in a public-private partnership, the opportunity to build all new additional buildings or increase, really, we're really just re-updating what we currently have there. Virtually the same amount of retail, movie theaters, station stays there. So the return on that is not all that great, but over the long run, we think it increases the value of everything. That's one of the reasons that our appraisal at $7 million, the town's at almost 10. We think the total benefits are going to cost, we don't have them fully priced out yet, but they're going to be more like 15, is partly in recognition that we're also solving the problem that long term we will be benefiting from this. You're absolutely right. We're one of the boats that gets lifted, we think, if this is a successful development.
So, right, so you are going to be able to charge higher rents, you're going to have, different clientele in there, and, so you do financially benefit.
On the office side.
On the retail side.
Well, the retail side is it'll be somewhat improved facility that we hope to get some more rent from. Whether it's going to justify the cost of it, I don't know. But yes, that should go up. And the office rents, we're hoping over time will go up. We have one important lease that's like a 15-year lease, so there's no change in the rent in that for a long time. But we're long-term holders, and so if we know we're going to own this for the long time, eventually we think the office rents will be helped too when our major leases roll over. But it's all looking out long-term. That's why we want the ownership situation resolved. We can't justify the investment if we don't know that we're going to be able to do exactly what you're talking about, which is benefit from this over the long term. I can hear you.
So the public benefit isn't, completely ours.
No. Part of it does help us. We're part of the public, so we benefit from it. But there are a lot of other trying to calculate. Once we know exactly what we're doing, we can do our best, or we can do it with the town, to try to figure out what the overall economic benefit to everyone is if this is a successful development. But as I said, that's sort of what the P&Z is. That they're encouraging development in a certain way because they think over the long run that's the best thing for Greenwich, and we're trying to fit into what what they'd like to see.
But we don't normally, when we're dealing with developers with P&Z, we don't normally go into a public-private partnership, but we still encourage what they're doing, right? So that part of that doesn't really count to me. What we're doing here is almost as beneficial to you as it is to us from my perspective. So it's hard to understand why we would give up air rights. And I think someone mentioned earlier that, that they're just air rights. We're not giving up the land, but we are, because we can't use anything above 8 feet or whatever it is on our property. We're giving up a considerable.
Well, they were leased for 90 years as it is, so that they did that,
but
thinking that would be an improvement for the town. The town has to make the same sort of judgment now. Is this something good for the town for the long run, or not? And that's what we've been discussing with the P&Z. But there's no way I'm going to argue that it's beneficial to everybody over the long term. Hopefully, and we are, in terms of doing a public-private partnership. We're already in one. We've been in one for 50 years, as far as we're concerned. We're just interlocked. And we're interlocked for many years to come on A level. We share in the revenues of A level. We got the long-term air rights lease. We're locked together, and I'm hoping we can make the relationship one that's more beneficial to both. Otherwise, we're incented not to really invest in this property, whether it's for improving the north side or whether it's for redoing the curtain wall on the the whole buildings, the portions that would be owned by the town and us, it's probably $15 to $20 million investment to do that. And is the town going to want us to do that or not want to do it? Unless we know the long-term ownership, we couldn't possibly justify that kind of a investment. So I'm agreeing with you that it's everyone in the area, but it's not just us. There's a public benefit beyond just a benefit to Ashforth.
Right,
Or
but-
the P&Z wouldn't be encouraging us to do it.
I guess I'm confused about the idea that if we just extended the lease an additional 50 years, so we're looking at, 2087, you still wouldn't put as much money into investing in redoing this building?
Right, that's right.
So the proposal that we're considering isn't that. We might get to that at some point, but I'd like to give the opportunity for other members to ask questions about the proposal under consideration. Mr. Burke.
Can you hear me? Yeah. Okay, Duncan Burke, District 2. This is a different kind of a question, but I believe this is coming towards us as a municipal improvement. Is that correct?
The request for municipal improvement status has been approved by the first selectman and second.
Board of Selectmen. This is such a grand and wonderful project, and there are so many interesting questions here today. I cannot believe what David Weisbrod has said and Mrs. Tarkington and essentially everyone. It seems to me coming forward as a municipal improvement, it has not enough. It seems like a simplistic approach to something that's that has a lot more scale to it than something that's simply a municipal improvement. I'm wondering if that structure going forward is adequate to take us forward with all the questions we have to get answered, and also I wonder if the timeframes that we have been thinking about going forward with certain timeframes are adequate to address all the questions that have come up today. I mean, it's a large and wonderful project. It should be wonderful for Greenwich and wonderful for Ashforth. But I think we need to dig in a little bit deeper here, and thank you very much.
Thank you, Mr. Burke. I think that's one of the questions that we had as well, whether, well, it was what I was going to close with my colleagues, which I'll get to at the very end, but there was the question for Mr. Tessie, whether he still intended to put the agreement as it stands on the RTM agenda for October.
Yes, first, Duncan, thank you for your question. As you know, municipal improvement is one part of the overall proposal. It's part of it because the town owns a portion of the underlying land, which has been the primary subject of today's deliberation. That then takes on a land use component, which they look at as part of any site development. In this case, it's a redevelopment, so that's part one. The lease is also tied to the municipal improvement. The lease is the financial and transactional part of it that reflects town interest being proposed to be sold. So this process is a deliberative one. It begins with the Board of Selectmen, as all municipal improvements does, as is the case with leases. So in the case of MI, as an example, with the Housing Authority, their projects also come before us. It goes to Planning and Zoning. The reason why this is here is not so much for the MI as it is for the lease and the significant financial interest that the town has, and the desire really to solicit the financial board's input into it. And if this was just a $1 a year lease for a boat club, it would not be before the BET, but it is, as was pointed out by several of the members, a significant transaction for our town. And I have to just say, I think everybody here has endeavored to bring forward very thoughtful questions, suggestions, and I took them in the spirit in which they're given, constructively, and know that this will take many months to adjudicate. As to your question, Madam Chairman, yes, I intend to put it on the RTM call in October, recognizing, having been a longtime member of the RTM and BET, that things take time. Committees are often formed. They do their own due diligence, and that there's no reason to delay what we know is an active issue. And I would just say that this issue with regard to the uncertainty, as I alluded to before with the ownership, was part of several appeals before the town that the selectmen review and approve, for which the BET liaisons are all copied on. So the BET also, too, has understood this is an ongoing element of the issue of valuation and uncertainty.
Ms. DeCastro, did you have a?
Hi, Rosalind DeCastro, RTM District 3. I have a very simple question, and that is, if in 57, in the 67, if the town had granted you the air rights, would we be here today? In other words, and I rarely use a train station, but it's very dilapidated, dark. Will we be 50 years down the road having this? I understand your interest in updating the retail, but will we end up with another dilapidated train station with no incentive for you to fix it?
Back in 67, it's pretty interesting, as I said earlier, it was viewed as a pretty terrific improvement. We think it's time to do it again. We don't have to do it. We're willing to do it. That's why we think it's a public benefit for us to do it. But we'd be incented to do it if we knew we were going to be able to benefit with our entire property from that. But if we don't, we will continue to maintain it. Maintaining it means normal repairs and fixing things up as needed, but ripping out ticket offices and restructuring and doing massive construction, which we think is called for there. We just really don't have an incentive to do that until we know what the long-term ownership of the total complex is. That's what we're trying to say. We think it's the right thing to do, but it's far beyond what our obligation is.
Right, but I'm thinking more of the future. Mm-hmm. If we give you the air rights or sell you the air rights, will you in 50 years keep up the station? Is there any incentive for it?
No, we're continue to be obligated. We'd have to redo the deed with Metro North. They've told us, they've been very helpful in this, that they do not need that ticket booth anymore. So when you walk up into the station, you'd be looking out, at the tracks and all across the tracks and so forth. So we would amend the deed with them, and then we'd be obligated to maintain that. And we would also agreeing that with the town as part of the redevelopment agreement, that whatever we do on that station, it'll be much more expensive to maintain, that we'd be taking on the obligation for the town, and including the south station and adding another station as well, and maintaining that. If there's a cash deal and that town wants to sell the air rights to help resolve the uncertainty, so we're encouraged to invest in the overall property, then we wouldn't be doing the public benefit portion, because we'd be paying it in cash, and the cash valuation is less, because all we're doing, once the town has the cash, that's it, and the transaction's over. We think this, what you like about this, is basically a win-win. The other thing I'd point out is normally in a public-private partnership, you give something to the developer and you hope they do a good job. It did that at the Stamford train station. It turned out to be a bomb because the developer was not a quality developer, frankly, I say as a competitor. In this situation, it's turned around. We have to perform, which the town was insistent on, the first selectman's office, that we have to perform all these public benefits. We have to get a certificate of occupancy. We have to show the money that was spent on them. We have to show that that's in excess of the fair market value of the air rights before we get the air rights. So we have to perform. So we're very incented. We're doubly incented to do it under this arrangement. But I hope that answers your question.
Thank you, Mr. Harvey. Ms. Swamley. And I do note that the BET members do want to get in their last word. So after Ms. Swamley, does anyone else have the intent to ask a question for the public? Okay.
I think the question that was just asked is a really important question, and it's one that people that I've discussed this with are troubled by, and that is, when this was when the deal was originally done, there were certain expectations that the buildings would be maintained, and they haven't been. And it's troubling to the people that I've been speaking with that they haven't been maintained, and yet we're 50 years out of the termination of the lease. And if we don't do something more for the next 50 years, this is what we're going to look at, and it's going to continue to deteriorate. So the question really is, why would we do a new deal if at some point in the future we have no more power to try to make it a better place? Why would we continue this if you're going to continue 50 years from now or whatever to say, yeah, we're not incented enough, we want more? And I'm very troubled by the question, the answer, and I think the community has that very real concern, is if you're prepared to let it just run to the ground for the next 50 years, what's to stop something in the future?
Thank you. I think the question really is, where's the provision in the agreement for the ongoing engagement of the town? If it's truly a public-private partnership, where's the documentation that the town sits at the table to ensure that the future maintenance of the public benefit improvements is maintained to the level of town satisfaction?
Good question. Trying to answer both. We feel we have met our obligations to maintain. I think the standard would probably be looking at other stations around Connecticut is probably a best standard. It's very hard to write into the agreement what you're going to do in 50 years. The structure is built in a way that I think there's a difference between maintenance and redesigning and rebuilding a building to new standards and coming to the P&Z for an entire new building and so forth. So what we would do is continue to maintain it and keep it clean. If you got to replace a floor, you replace a floor. You got to replace a ceiling, you replace ceilings. But that's different than investing in an entirely new design. The issue of trying to predict what would be doing, and a good structure can often last more than 50 years. There are plenty of wonderful structures in the city and stuff that, well maintained, can last a lot longer than 50 years. So in terms of trying to anticipate how long the building, and it would be better built, I believe, under modern construction techniques, but trying to figure out, and I'm open to it, is trying to figure out how at some point, if there's a desire to have it be completely rebuilt, that's a new issue, trying to anticipate down the road. We are obligated to maintain it, and that's where I would say maintaining the structure and having it continue to operate properly and so forth, but an obligation to build what is people think, and by the way, there are a lot of different opinions on what this building ought to look like. Trying to figure that out 50 years ahead of time would be tough. But I appreciate the question, and it's inherent probably in public-private partnerships, where I think we've tried to design something that we're hoping would be of an architecture that would last for 50 to 70 years. But who knows how trains are being used? Who knows what people are moving around, what transportation is? But we can only look out so far. But we will continue to maintain this. I've had a number of people say it operates fine. I get on the train and I don't really want to see a change. I happen to be a believer that the future for Connecticut really is going to relate to mass transit versus 95, and this could be an opportunity for Greenwich to be a leader, at least for the 50 years. I'm just having trouble predicting beyond.
Mr. Harvey, Mr. Brennan, did you want to add something on that?
Very quickly, Exhibit G has the concept, but not to the extent that was just discussed. But Exhibit G is a joint operating and maintenance agreement,
Right.
but it does not address the 50-year issue.
Okay, thank you. And while I have you, do you have did the proposals that Mr. Weisbrod referenced give any cost estimates for the redevelopment work? So when you received a proposal for a consultant to help assist the town with the redevelopment, which you determined was premature and too costly, what were the cost estimates of those proposals?
I believe it was around a retainage. I think it was a blended, two different numbers, but the number that sticks in my head is 20,000 per month.
So if you have copies of the proposed proposals, if you could forward them to me and I'll distribute them to the BET, that would be useful for us to understand. Ms. Moriarty, then Ms. Hess.
I just wanted to point the obvious fact and to Mr. Tessie's intention of moving forward to the RTM on the next step. Now, I realize the town processes are pretty rigid, but what's being asked of the BET by us being mentioned in the contract in the RTM is really an up or down vote on the deal being presented. And yet you've heard many concerns by BET members, one in questioning valuations, but the structure of the deal. We've heard many RTM members talk about structure of the deal. You've worked on this for over a year before it even went public, without involvement of any of the other town bodies to get other views and potentially assistance in crafting a transaction that might be more palatable. I question whether it's a good use of time to ask for that up or down vote, or whether there isn't a different process to try to find what are the key issues that are of concern to resolve those so that all of the town bodies are really facing a transaction structure or an approach that has a better chance of success.
Again, as I outlined earlier, I think the BET certainly was aware of the issues surrounding Greenwich Plaza. As it's been noted, it's been a 50-year relationship. I think you also know that we have a decentralized form of government that places responsibility and authority into the various boards and positions. As chief elected official, it's my job to interface with residents, businesses, and in this case, with this particular entity as leases begin in the office of the first selectman, as our lease policy was outlined, as you recall, back sometime 2010-11. So in terms of being aware, until we have a concrete proposal, I don't think there's a necessity to have dual agencies negotiating on behalf of the town. I think it creates a great deal of confusion and blurs the line of responsibility. Just like I'm not involved in your appointments of your comptroller or your assessor or many of the issues that you deal with related to the pension board and agreements and so forth. So we follow process. We follow the authorities that are vested in the boards. In terms of your desire to address this, you've been given full purview. You can convene further meetings. You can present your questions. It is our prerogative if we want to send it to the RTM. I think the RTM's fully well aware of it. This would give them further opportunity to engage the way they want to. If they want to hold up based upon your board's decision to do something different, they can do that. I think it leaves the discretion to them rather than my trying to control what they do or not do. And with the change in administration, I think the continuity certainly comes into play with a respected professional administrator. And as I said too, P&Z is operating on their own independent course. Greenwich Plaza could conceivably, and I don't speak for them, go forward in request improvements to the parcel 1 along Railroad and not do anything with this. But again, this has been looked at holistically, I think, as we've heard, because they all are interrelated. The public benefit is on that side. So,
Ms. Hess.
Oh, and I do have to get on a call for the Regional Council of Government meeting, so I will have to leave.
Is your question for, do we have any further, Mr. Weisbrod, do you have a question for Mr. Tessie before he leaves?
Just sorry, before you leave, Mr. Tessie, the agreement says that the agreement shall not take effect unless and until it has been signed by both the town and GPI following approval by the Greenwich Representative Town Meeting and the Board of Estimate and Taxation. So you need a vote from this body, from the BET, before you can proceed. I guess it's your purview. It's within your purview to take it to the RTM absent a vote, but just to make sure it's clear to everybody, without the approval of the BET, there is no agreement. Is that your understanding?
Very much so, and intentionally. And again, the RTM can choose to do what they like with it, but it formally puts it before them, I think, to engage them, again, in a more formal way, because it will be an item on their call. And as we've had with ordinances, oftentimes, which, again, start with the selectmen, they've taken them up, they've crafted them, and then they've come back to the selectmen. I foresee that being the case here, the difference being BET is an integral part of it. So, again, as a closing, I want to say there's been a lot of constructive points made. And again, this is a point of departure we've had over the last several months, and we'll look forward to engaging. At least I will over the next 70 days.
Mr. Tessie, thank you for your participation. Ms. Hess.
I just want to come back to the maintenance point for a second. I think there was a couple of interesting points raised. I get that you're complying with your requirements to maintain the facility. I think the point, though, is that minimum maintenance is resulting in a facility that is somewhat viewed as being maybe a little outdated and dilapidated. So I think the question that we're just trying to answer, and maybe you don't have an answer today, though, is assuming this goes through, we don't want to be here in 50 years and find ourselves in another dilapidated facility that hasn't been modernized. I think that's the point you were trying to make. And so what assurances do we have that so like if you own a hotel, right, you generally every 10 years you'll turn it over and you'll renovate. So what requirement may there be to make sure that we're not sitting here with a dilapidated facility, 50 years out? And maybe you can't answer that, but just something to think about.
Sure. I just haven't seen it, and that doesn't mean it doesn't exist out there, but I haven't seen an agreement with a long-term building of a building that there's an agreement to replace it in some fashion or spend a certain amount of money to completely rebuild the building at some point in the future. I've just never seen that in any because it's so difficult to figure out what you're committing yourself to. I haven't. See, I'm open to where other places where I've done it, but you hope every developer, when they're doing a building like this with an architect, they hope it's going to be, something that's there for a long time, like other buildings in Greenwich or like Grand Central Station or something, and you'd be maybe renovating the interior to upgrade, but you'd hope that it's built in a way that it could really last. I honestly don't think that, if it asked in 1967 to try to imagine what it would be like in 2019 and what should be built and what we would have obligated ourselves to build, I'm not sure a typical owner would do it. But I understand exactly what you're saying. I'm just not sure that I have an answer or could find out some way of fairly trying to do that. But you hope it's going to be a building that they renovated Grand Central without having to rebuild the whole thing because people liked it, and we're hoping this would be something that symbolizes this period of architecture. And there are plenty of buildings on Greenwich Avenue that have met the test, and our architect hopes that this would also meet the test.
Thank you, Mr. Harvey. I can see by the hands in the room that a lot of people have a lot more to say. We have really reached, after 2.5 hours of discussion, I think I'm going to close the discussion, actually, because we could keep going probably for another couple of hours. I do want to ask my colleagues, I know people have a lot of comments, but I do want to ask my colleagues, my intent is to have it on the agenda as a discussion item, not for a vote on Monday. I just want to make sure that's consistent with what my colleagues would like to do. If anyone would like to take a vote on the agreement, I'd ask you to please let me know. We can, in the discussion, hope to narrow down some of the questions, continuing questions that we might have for both the town and for Greenwich Plaza. If anyone wants to speak on the agenda item for Monday specifically related to this, please let me know now. Ms. Tarkington, I see you raising your hand animatedly. Is it specific to the question of the agenda item? We're
I
really...
wanted to ask a question about agenda item because I think it relates to us too. After Mr. Burke's question, and while Mr. Tessie was still here, but maybe I should ask, I'm not sure if Mr. Harvey or Mr. Fox, I do want to understand, Mr. Burke asked a question about MI, and I have a copy of the final agenda. Can I ask? No, because I think
No,
it's
Ms.
important.
Ms. Tarkington,
Has the MI started yet?
Ms.
Has the MI application been started yet?
Mr. Branyan?
It has started. The Board of Selectmen referred it to Planning and Zoning. Planning and Zoning is scheduled a special meeting next week, Thursday, the 26th at 7 p.m. Item 1 will be the MI. Item 2 will be follow-up from the prior meeting they had. It's the
I
first
believe that
meeting
was
being-
referenced earlier in the meeting by Mr. Harvey. We're not going to take further discussion on this right now. Unfortunately, we are out of time. People have other commitments to go to. I will ask BET members to, if they have follow-up questions, if they could submit them in writing so that we can forward them to both Greenwich Plaza and the town, and we can maybe get answers. Again, for all the people who've attended, the public, if they have questions that they would like to forward us, that we can forward them to the town or Greenwich Plaza, we're happy to accommodate that as well. I do really appreciate your attendance, your interests, and your questions. And before we close, I'd like to extend a thank you to both the town and their representatives and Greenwich Plaza and their representatives. We know that this has been an enormous dedication of time and resources, both your time resources and economic, on this partnership, looking to develop the best relationship going forward. We do really appreciate your willingness to answer every question asked and your participation, so thank you. Can I have a motion to adjourn? Second, all in favor? Aye, adjourned at 11:39.
I know you.